Okay, greetings everybody. Keith here, hoping everybody's having a good day, enjoying life, living life, and loving life. Coming at you today to finish up the stream from yesterday on equity. And of course, I want to remind everybody, hit the like, share, and subscribe button. I appreciate everybody's support there. And of course, there's PayPal links in the chat section below, the details to share some love if anybody would do that. Everything is appreciated. And the panel link is pinned for anybody who wants to join the panel. And let's see here. We're going to get into it. Today is not going to be near as long as yesterday. We went 9.5 hours on it. I thought I'd be able to finish it up, but we got some more to do, so we're going to finish her up today. It's not going to be near as long. So, into it. Make my screen larger. Where did it go? There we go. Okay, continuing. This is where we left off yesterday. Rules of law, working for the entire protection of Americans. Agency. So let's start back there again. Agency law. Okay, agency law is concerned with any principal agent relationship, a relationship in which one person has legal authority to act for another. Such relationships arise from explicit appointment or by implication. And this is what this entire system runs on. You have certain personnel of the government that are appointed, and all of the rest of the people that are born in the states are by implication a principal or agent because of the terms that they're born under through the enumeration of birth that implies that they are national of the United States by conference of a United States nationality known as a United States citizen as part of the United States citizenship. And everybody's claiming that they're a United States citizen and a resident when that is in fact not true unless you've gone through certain things to organize under the laws of the United States as one of those corporate entities. The relationships generally associated with agency law include guardian ward, executor or administrator decedent, and employer employee. And like I mentioned yesterday, these all are like contract setups. An employer employee situation is a contract setup. A principal agent relationship is a contract setup. Guardian ward, executor or administrator decedent, those are terms generally you see in trust law. And so when we see agency law is concerned with principal agent, it's talking about the contracts within the trust. Always going to be both of them combined together. This is the dual jurisdiction, trust law and contract law. Law of agency is based on the Latin maxim, qui facet per alium facet per se, which means he who acts through another is deemed in law to do it himself. This is the way, the light, and the life, Jesus. We're supposed to be an agent of the principle of the spiritual realm in this Christian and Islam and Judaic religious setup that we have through the Abrahamic religions, at least here in the Americas. Fettering of rights of inherent legacy defined. It's alike worded as breach of trust and or executor des tort. Anytime somebody's administrating your estate, And I want people to understand your estate is much more closer to your natural essence than any kind of fictional idea. So when we talk about our estate, it's your actual life. You yourself, living and breathing, are the estate. And if somebody else is trying to administrate yourself, that is executor days on tort. And what happens in these administrative courts is, like I've said many times, they operate under a probate. In other words, the estates of decedents. They are administrating estates of decedents, people that are supposedly deceased, or the presumption that the entity as a decedent has never lived. What happens if a trustee, if a trust has no trustee, no trustee will be available to manage the trust or make a claim against it. So anytime somebody makes a claim against the estate, what they're doing is they're acting as a trustee, making a claim against the estate. Those are the only people that can make a claim against another estate, is by saying, hey, you're violating my estate. Courts, they're administrating commercial objectives as if though you're in violation of some other estate. And that's false. They are not of like kind. It's not an estate in trust. What they're doing is running contracts, and they're running contracts as if though you're another trustee, an agent, because you're using the resident and U.S. citizen determinations. You're not supposed to be doing that. That's an implication that you're a trustee. You're implying that you're a trustee because you took upon that presumption without finding out for sure whether you were a United States citizen, which I've explained many times. According to the construct of the language in plain writing, there is no possibility for you to be a United States citizen. It doesn't exist. If there is no birth registration in the United States, then you cannot be born in the United States, and the conference of a U.S. nationality doesn't exist. There is no United States nation. Okay? In such cases, beneficiaries will need to go to court to resolve the matter. Again, if you go to court, then you're acting still like a trustee. This is not true. You cannot walk into those courts and leave with, or let the court sit with that presumption. And as soon as you do walk into that court, you're acting in the capacity of a trustee, and you're doing so voluntarily. And like I said, one of the maxims of equity is equity does not aid a volunteer. You have to be diligent in what you're doing and not volunteer. You cannot do it in a public capacity as if though you're a public official, and therefore the only place equity exists is in the private. And it may be time consuming and difficult to get it resolved. I've been working on this stuff for 7 years. The will equivalent to the trustee is the executor. This is why they depend on that will. Equivalent to the trustee is the executor. Yourself, you have to pose your will. I didn't say state your will, pose your will. This is your actions speak louder than words. If you act like Jesus and walk like Jesus and live like Jesus and love like Jesus, you are the way like Jesus. You are walking the way like Jesus with no liability. Come with repentance if need be. And I think everybody needs to come with repentance because, like I said yesterday, nobody is perfect. We all know this. Herald the intended receiver of the estate, which is what I've said has never been done. It's his estate. It's his life. You belong to him. What I'm talking about here, and when I say his, all capital letters, that's what I use to reference to God, the source of life. You belong to the source of life, just like the source of life belongs to you. They work cohesively together. The executor of an estate will need to oversee the payment of claims and debts from the assets of the estate, including the executor is usually not personally liable for them. Why? Because the grantor placed all liability. You do not have to accept liability. If you find as an executor that you're taking on a liability instead of a responsibility of executing the estate, then that liability is in that the will that you're supposed to execute. If there's a liability in that will, then the system is likely going to see that that will wasn't constructed properly because it's laying a liability instead of passing on a benefit. Okay. See, that's what the execution is. The executor is supposed to execute the will, and the will is supposed to be a benefit to the beneficiary that the grantor, the testator who has deceased and passed on, is now passing on his benefit of his life to a beneficiary for their life. In some cases, however, the estate may not need to repay a certain type of debt. Again, owe no man anything but to love one another. For this is to fulfill the law. So the next one is absolute. Absolute means unconditional, unfettered, completed, perfect. This is what they talk about them legal titles being perfected. The only way you can actually perfect a legal title as a beneficiary is the collapsing of the trust. And that's when the legal title meets the equitable title. That means you have to be the holder in due course as receiver. Go get that damn title. That's what I was talking about with the county registrar. They're holding a document of title that was never financed properly. And it's placed liabilities in, on, and for the record when it was supposed to be for your benefit. And instead, it's caused you detriment all your life, though it was placed in the record and is in a trust situation and is meant for the beneficiary. They know this. This is the entire construct of trust law. Yet they hold that document and it's used in those administrative courts as if though you're dead because you never come to get it. But yet while they pull you into court, they know you're alive. If they know you're alive and they're pulling you into court and they know that document exists, why aren't they giving you that document like you're supposed to receive it and say, hey, you better grow up. This is how you're supposed to act. Here's your benefit. You better do what you're supposed to. Go educate yourself. That's the true benefit. Nobody does this. Nobody even teaches you that it's there. Admiralty Court. An admiralty court is a tribunal with jurisdiction over maritime law. So an admiralty court has jurisdiction over maritime law. So when they're doing the maritime contracts, again, it's under the jurisdiction of admiralty, which is a trust law, including cases regarding shipping, ocean, and sea laws. Did you know that the only way to condemn land for agricultural use is that if it's been submerged underwater? Section 18, Title 18 of the U.S. Code, Section 7, Special Maritime Territorial Jurisdiction, which is an overlay of the territorial jurisdiction regarding shipping, ocean, and sea laws. That placates that the people on the land, as the United States citizens, are the obligors that hold the obligation and other securities of the United States as resident agents within the states. And they're residing over United States vessels under Article or Section 18 U.S.C. 9. So it's 18 U.S.C. 7, 18 U.S.C. 8, and 18 U.S.C. 9 is the basic construction of all of this, the whole thing that's destroying your life. Historically, admiralty courts were a separate part of the court system. Historically, admiralty courts were a separate part of the court system. When equity merged with common law That's when they merged the admiralty with maritime law. But admiralty is the trust law, and it has jurisdiction over the maritime law. The same way equity has jurisdiction over common law. It was merged, but it is common law is a court of law within equity. In the U.S., any court, let me finish this up. In modern times, these cases may be assigned with the regular court system, usually at the federal or superior court level. What they're doing is they're using the administrative courts as if though the contract says you're already in maritime jurisdiction. So therefore, they subvert the actual maritime jurisdiction in the admiralty court tribunals as if though that part's already been done, and they're just administrating the contracts that are under that jurisdiction, which is the lowest jurisdiction there is. Commercial contract law is the lowest jurisdiction there is. In the U.S., any court that is hearing a maritime case is an admiralty court for the duration of that case. In the U.S., I beg that if the court is presenting an admiralty flag, then all cases in that court for the duration of that court are a maritime case. That's why they require you have some kind of merchant license or merchant ID saying that you are a resident or U.S. citizen. Privy, a person who is in privity with another, one who is a partaker or has any part or interest in any action, matter, or thing. So while you're growing up, you have an interest, a very deep interest in the name, the given name, Keith. And you also have an interest in the family name. Those are two different interests. They combine them, creating the dual jurisdiction, indicating that there's a probate estate in the administrative courts because they have contractual paper that they can instrumentalize governmentally. Privity, as an adjective, the word has practically the same meaning as private. It is not the same, but it has practically the same meaning. Like I said yesterday, contracts have the very first element of contracts is privacy. They are between two private people that are partaking because they have an interest in an action, matter, or thing, whether in the past or in the future. It's an intended thing. And then Malika, as we saw yesterday, was speaking about a bill of peace, bill of review. And this is where we're going to start checking those. Cross bill. An equitable bill by which a party to a suit can bring a claim against any other party. Note, under Federal Rules of Civil Procedure 13, cross bills are replaced by counterclaims and cross claims. So the cross bill and cross bill is the same thing as a counterclaim or cross claim. So you can say that a cross bill is a cross claim, and therefore a claim is a bill. When anybody makes a claim in one of those courts, they are presenting a financial instrument, an invoice of costs, bill of costs, a bill setting forth the expenses in connection with a suit that a party seeks to have paid by an opposing party. Does the opposing party have an interest in it? If he changed his name and no longer wants to carry that name, then he's given up his interest in that name. You can't present a bill of costs against somebody as such. And these courts admit you can change your name. But remember, the change of name isn't to avoid legal or lawful consequences. If you're doing it to avoid a bill of costs that they present, then you've done it too late. You have to deal with that bill of costs in the name that sits that you do have an interest in yet. And again, like I said yesterday, it used to be that a beneficiary wasn't required to do anything, but because they merged equity with common law and they placate that you have to know something in order to go into those courts in an administrative capacity and comprehend the language, it brings on some sort of literacy. Again, equity exists without literacy. Bill of review. An equitable bill used to start a suit to have the final judgment of a previous suit set aside. Compare bill in nature of a bill of review in this entry. Note, bills of review are used when another device for review, such as appeal, is not available, as when the period to bring it has expired. So when they say, oh no, you can't do that anymore, no, equity does not have a statute of fraud or a statute of time, like the statutes of fraud has a 7-year time limit. Equity has no time. Equity is as is. Equity is what is done is what ought be done. There is nothing new. Bills of review are abolished in federal practice by Federal Rule of Civil Procedure 60B. Bills of review are abolished in federal practice. That means trustee. Federal practice by federal personnel or other principal agent relationships is a trust position. And they are acting as trustee. They can't bring equity as a trustee. They can only bring a bill of costs. So as a beneficiary or benefactor, again, you have to come in as a third party to the contract, letting them know that even though the name in the contract might be similar to yours, it is a legal name that placates that it belongs to you, when in fact you are not the creator of it. The state created it in their record keeping, as if though you were born a resident in their state and created a legal fiction through a legal name, a conversion, translation of the given name and family name into one name known as the legal name that is identified by a first and last name together. And yes, Janine Matos says beneficiaries can come in when the trustees fail to protect the trust and or beneficiaries, or when the trustees breach. That's the trustee or trust is breached. Yes, and that's the whole idea of perfection, is that if they breach the trust, then the trust wasn't created in perfection, and therefore it allowed for a breach. And now that the trust has been breached, it has to be corrected as close as possible. And if they can maintain it as a trust, then it can remain as the trust. But if they can't, then it has to be collapsed. And when we find out that there is no power of attorney, and they've all been acting as executor des tort, as if though they are allowed to act for somebody else as principal when they're not even an agent, then they have to quit being that principal for people that are not agents. They can only be principal agent relationships if they have that constructed contract before them. It has to be there. It cannot be presumed or implied. But because that citizenship is an implication, everybody takes it and, oh my God, they start signing all kinds of documents, thinking they've been empowered because they're a citizen of one of the greatest nations in the world. The United States is not a nation. It cannot be a nation. It is a corporation. It is a federal corporation. And as a corporation, they are the trustee. They cannot do anything but practice in a federal realm. Period. A bill of peace Bill of peace, when entertained, is an ancillary injunction. It's an estoppel. It says, hey, wait a minute. There's something wrong with this trust, not the contract, the trust. And when it being in the interest of this state that there shall be an end of litigation, equity will entertain a bill of peace. And this is the perfect example for everybody to pay attention to. There are 93 cases that have been litigated in these courts in that name of Keith Orland Little. 93 cases that have been litigated. And I, myself, alone, one little man, little old me, Keith, can prove that all of it is a violation of trust law. I can prove it. I'm not going to say it's fraud, but I can say it violates trust law and things were done wrong and we have to correct them. In trying to correct them, if that trust can remain, it will remain. But if it can't, then it won't. It has to be collapsed. This is an absolute. You cannot force somebody to operate in a trust as a trustee if he is not, in fact, a trustee. And you cannot enforce a trust that doesn't exist for lack of trustee. To avoid a multiplicity of actions by establishing a right. So again, the merger of equity with common law, it used to be that the beneficiary did not have to do anything, but because of the modern federal practices and that merger, now to avoid a multiplicity of actions by establishing a right, the beneficiary is the one that has to come forward and do that. The trustee will never do anything but act upon the presumption, and they will always act on that presumption until somebody properly comes forth and rebuts it, because that's what they are trained in. They are trained and educated to act on that presumption, just like you were in that public education system where you were indoctrinated into writing the legal name instead of comprehending the difference between the legal name and your given name and last name, or family name, excuse me. The grant says Trading with the Enemy Act granted the registrars a power of attorney. What the problem here is that if there is no testator and there is no will, and they're probating an estate that has no will, then there is no will to grant a power of attorney. They can't just say, okay, well, we're going to grant a power of attorney over something that we created and placated as if though it belongs to him. It doesn't. It doesn't work that way. They created a legal name which presumes or implies that there's a power of attorney in there, and there never is. You cannot just grant something that can't be granted. Mom and dad did not grant that. You cannot just assume a power of grants. While I admit that that's what they presume, Trading with the Enemy Act does, in fact, supposedly grant powers of attorney over belligerent combatants and incompetent minors. I and everybody in the society can tell when one of our children is rather full grown. If they're born here, then they can't be an enemy. I would think that if they resided somewhere, then they might possibly be an enemy, and that would be the only implication that there's a possible trading with an enemy going on. Think about it. I resided. I once was a German Nazi. Now I resided. I'm a Jewish Nazi. Not what do they call it? Not it's close to Nazi. Not I've got a brain fart again. Not Kazani Zoo or what, Jew or whatever. Anyway, we're not going to play with that anymore. The thing is that the beneficiary has to do something now because nobody else will. That estate is listed in a corporate fashion that is total fiction and can't do anything for itself. And all they're going to do is hold it until somebody comes forth and claim it. Okay. In favor of or against several persons. And that in favor of is I'm claiming the rights of both my mom and dad and myself as their legacy heir. They had rights. They missed out on those rights, or it was placated that they didn't know them or whatever, and it didn't get passed on in that documentation. And therefore, I know that they didn't express those rights and make that claim because it's still sitting in the county registrar. If they'd have made that claim upon enumeration at birth, that document would have been handed back to them, and they would have been able to collapse the trust that the state was trying to create within the next 90 days. But since that didn't happen, I have to claim those rights too. This is claiming your birthright, which is likely to be the subject of legal controversy. How do we know it's likely to be subject of legal controversy? Because it's been held as a legal controversy against me for 93 cases. It's already got a record that it was subject of legal controversy. Every one of those cases is a controversy. Or in other similar cases, such as to confirm some right which has been previously satisfactorily established by more than one legal trial and is likely to be litigated again. So again, to avoid a multiplicity of suits, the beneficiary has to come up and make a claim against that suit, or all of them, as an inherent birthright that has made a controversy out of his entire life. My life is not the controversy, the legal fiction is. As ancillary to this jurisdiction, equity will grant perpetual injunctions. So again, as I said, going back and claiming your mom and dad's rights, it grants the perpetual injunction from that point on, which would include, again, your legacy heirs as well. Yet, as soon as you die and don't pose a will in their administrative courts, it goes that your children will be dragged in to that court again. Saying that equity will grant a perpetual injunction is almost facetious. It's almost blasphemous. We know as a record of throughout history that it's done repeatedly over and over again in every instance. An equitable bill used to settle the rights of parties in one suit and avoid repeated litigation. And again, we're coming forth the benefactor, the one that put all the facts in the record, gave them all the data elements. We've got to come back as benefactor and settle the estate trust. Remember, we talked about the beneficiary. It can step forth and settle the trust as settler. The settler, as beneficiary, benefactor, as settler, can step forth and dismiss the trustee if he wants to or needs to. Or he can step forth and recognize the trust is without a trustee and settle the trust. Or he can step forward and recognize the trustee and settle the trust with the trustee by holding the trustee to his obligations of trust. Several ways it can be done. Private bill, a bill affecting a particular person, organization, or locality as distinguished from all the people or the whole area of a political unit. Now, remember, I talked to you about the graph I showed you with the state's vital statistics jurisdiction that is created upon enumeration at birth when you are born in that hospital. This is the exclusive jurisdiction that is distinguished from all the people or the whole area of a political unit. Now, the political unit as that area is the district, which we spoke of yesterday, where they might find in their zone certain principals and agents that are acting in contract, but are in fact American citizens in the district. Showing us the political unit of a foreign trade zone is one thing that conducts the affairs through principals and agents, whereas the district is another jurisdiction under the foreign trade zone. Just like we saw maritime is under admiralty, the district is a political unit underneath the foreign trade zone. Each political unit, each district has American citizens that vote for a particular political unit within that foreign trade zone. You're not born in that foreign trade zone or that political unit. You are foreign to that, and you are born in that area. See how the language works? In the area of a political unit, and the documentation that arises from that in a political or foreign trade zone or commercial or maritime or admiralty term is a commercial setup. It's all for commerce. And it uses the term birth and not born. They destroy your privacy when you're born in those hospitals, creating a public entity, and everybody is indoctrinated into living their life as a public entity. That is not you. Under fine law that says a bill of peace was an English court practice used in the 17th and 18th centuries for legal disputes involving multiple parties that shared common aspects. This is that damn public domain, the eminent domain, the public interest. Under the public interest, you have common aspects because you're working, living, and breathing and doing things in the common area, a centralized location of a political unit, a foreign trade zone, a society, a city, a municipality, things like that. And when we think about that term citizen, it literally means city person. You are of the city. So if you're of the city, then how are you a United States national? How are you a citizen of the United States and a citizen of the municipality? See, you're living a dual jurisdiction your entire life and don't know it. And in fact, you're not either one of them. Those are both false jurisdictions, fictional jurisdictions, because the jurisdiction you come from is spiritual. And this world does not see the spiritual essence. You are in this world, but you are not of this world. So we continue on. It says a bill filed to procure. See, you're actually coming forth to cure. Pro meaning future. A bill filed to future cure. It's stating an intent that in the future, as we go along, we want to fix the things as we find them. That's what you're doing. It's what a doctor does, supposedly. He cures you. No, he doesn't. A bill filled or filed to procure repose. Remember what I said earlier when I started out the stream today is pose. That's your pose. When you have somebody, a model pose for you for a drawing or a sculpture, you have them stand there and tell them, well, move your right arm this way a little bit. Now open your hand a little bit. Now lift your thumb a little bit. Oh, no, too much. You're having him pose. You're making a presentation that can be observed by other people. So what you're doing as a benefactor, trying to fix this record, is you're reposing what they posed in error, or what you helped them pose in error, or what they posed and then you joined in error. Whatever it is, it's in error, and it was a posing in error. It was a positioning in error. And then you go to court, and the first hearing is a disposition hearing. They're dispositioning you again. They're deposing you. You need to repose. Okay? And you do it from outside of the court. From repeated litigation is termed bill of peace. So again, we see these different terms that are talking about repeated litigation. This is why I say to help sustain the state's budget and prevent them from putting further expense into fictional violation into fictional claims that are violations of both contract and trust law. We're going to fix this now. It's not going to happen anymore. It's an acquittal. It's a full acquittance. It's an estoppel. It's an injunction. Stop it. Quit doing it. You're doing it wrong. It is one of the earliest instances in which chancery courts entertain jurisdiction on the ground of preventing a multiplicity of suits. This is one of the reasons they merged equity with common law, because the idiots back in the day kept making false claims against people, and they found out that if you just put them through before a jury of 12 other idiots, that jury of 12 other idiots will convict them. And I'll be damned if that's common law proving itself not to be effective. How can you have a jury of 12 people being competent if they're claiming that they're a United States citizen and a resident when in fact they are not? It just behooves me to understand why we are not taught this. And it is so damn simple. So we continue on with a little story here. It says, the king of Brobdingnag gave it for his opinion that whoever could make 2 ears of corn or 2 blades of grass to grow on a spot of ground where only one grew before would deserve better of mankind, and do more essential service to his countrymen than a whole race of politicians put together. See, everything has its time, place, and space. And as we come up in this commercial environment, and we have this greed and gluttony, we want more and more and more. This is why we have people trying to plant 2 blades of grass in one spot. This is why we have multi-family living units, where we have multiple families living in one spot. Do you think that deserves better of mankind, or does mankind deserve better separation and an individuality of that exclusiveness that I talked about? See, this is placating that, where you can put all kinds of people in one spot, and then that man deserves better of mankind. I doubt it. I doubt it. I did 7 months up in the mountains in the Appalachians in a goddamn tent, and I was much better off for it. I don't like society. I don't like bumping elbows and cocks with everybody else. I don't want to be lined up butt cheek to butt cheek with everybody else. I want my room, space, and my time. And I'd like to be able to do it alone when I want to, and enjoying with others when I want to. I don't want it to be placated anymore that I have to do this with other people because those other people want me to. And if I'll be damned if 10 of them are going to come grab me up and tell me I have to, then they're going to do that. But there's nothing I can do about it. The fuck there isn't. I'll fight tooth and nail. You do not have authority over me unless I've committed a crime. And do more essential service to his countrymen than a whole race of politicians put together. That I can believe, because these politicians don't do a fucking thing. In fact, these politicians are doing what the people want them to do when it comes to plastic straws. They legislate out the plastic straw in a paper wrap, and we end up with paper straws in plastic wraps, while totally ignoring the entire problem itself is the plastics that you turn around and put that damn straw into, the plastic lid and the plastic cup. What about them? It's just idiocy. In matters of justice, however, the benefactor is the one who makes one lawsuit grow where 2 grew before. See, these people are trying to grow 93 cases in one place. I'm going to show them how to grow that one. We're going to pick all those weeds, and we're going to let a valiant plant grow now. A potent device for this purpose is the Bill of Peace and Equity. Questions of law or fact which would otherwise be tried over and over, and this is why they tell you you don't question a law of fact of questions. You don't question the law or facts. You question the intent. You question the intent. Because once you question the intent, then it is resolved as to whether the effect matched or not. With these suits here that they have, nobody's questioning the intent. They're still questioning the law or fact, and then it gets tried over and over. You don't go into court and claim or question the law or fact of traveling. You claim your intent as a sojourner and stranger with him in all of his lands, which shall not be sold forever, because your purpose from him is to be the redeemer he made you to be, redeeming the land and the brothers and sisters you run across as you sojourn with him in and out, that he preserves. The Lord shall preserve thy going out and thy coming in from this time forth and even forevermore. That is the perpetualness. That is the intent. That is the injunction. That is the estoppel. And it goes along with his original promise and his original oath. So why would you walk into a court that has given you a note as a promise with a false signature and a false oath? Can by this means be determined once and for all in a single proceeding. And this is why I say when you're born through that enumeration at birth, the intent by mom and dad is not put there to hark and herald the angels, or like the angels, the legacy heir, the arrival of a legacy heir. You haven't made your birthright. Like I said, the 12 names of the tribes of Israel, the 12 sons of Jacob, when put in the correct order, spell out the birthright. And shall say, I am the Lord's. One shall call himself by the name Jacob, and one shall subscribe, another shall subscribe with his hand unto the Lord, and call and subscribe himself by the name or by the surname Israel. It's a simple instruction, and it clarifies the intent of bringing the word of God. This avoidance of multiplicity of suits saves parties from needless expense and vexation. The avoidance of multiplicity of suits to help sustain the state's budget, to prevent them from litigating this over and over again. We're going to stop it now by placing the intent into the record. That way we can dismiss all the false facts that I placed into the record. Okay? Economizes the time of judges and jurymen and frees the docket for the affairs of other litigants. I guess I need a little English help there. Needless. I forgot an S and I forgot something in there. And we're going to finish up here with Article 2, Section 3, Article 3, Section 2, Clause 1 of the Constitution. This is the common law, Article 3 courts, not the administrative Article 1 commercial courts, Admiralty Maritime. You can't go into those courts that would place you as an administrator by your actions. You have to quit volunteering to do that. You're voluntarily going in there. Equity does not aid a volunteer. So you must demand through paperwork in Article 3, Section 2, Clause 1 of the Constitution, extended the federal judicial power to all cases in law and equity arising under the Constitution. So their claims under the constitutional authority that is affecting you extrajudicially, because you are not part of their judicial office, part of their judicial body, you are extrajudicial, and they are making a prisoner out of you by using that legal name against you in every case, threatening you with jail if you don't act as the agent like you're supposed to under the Constitution. You did not take an oath to that Constitution. You are not subject to that Constitution like they are. However, the Constitution under Article 3, notice it says Article 3. It is not an amendment. Get it right. It is not the First Amendment. It is not the Second Amendment. It is not the Third Amendment. These are articles of the Bill of Rights. The 11th is the amendment. 11th Amendment is an amendment made after the Bill of Rights. The Bill of Rights, the Constitution and the Bill of Rights was constructed. Then they amended it. Okay? The first 10 are articles, literary articles, and they are protected under the Treaty of Berne. Okay? All cases in law and equity arising under this Constitution. The laws of the United States and treaties made or which shall be made under their authority. Treaty of Berne, literary and artistic works that allow you under this Constitution and the first article, freedom of association, freedom of the press is your right to express yourself literally and artistically. And it is also at the same time equivocal. There is an equality of equity. There's a sort of equality with other people that you express yourself to, known as their right to know. This is the basis of equity. In my opinion, of course. I'm certainly no Joseph Story or anybody else. But my interpretation is that equity has to do with the two parties involved. One has the right to express themselves, the other has the right to know, and nobody is allowed or supposed to be allowed to interfere with that. In Section 11 of the Judiciary Act of 1789, Congress provided the circuit courts, Article 1 courts, with original jurisdiction over equity cases in which more than $500 was in dispute when the United States was plaintiff or petitioner, an alien was a party, or the suit was between a citizen of the state where the suit was brought and the citizen of a different state. I'll read that again. In Section 11 of the Judiciary Act of 1789, wherein those administrative courts were established, was plaintiff, or Congress provided circuit courts with original jurisdiction over equity cases in which more than $500 was in dispute when the United States was plaintiff or petitioner. An alien was a party, or the suit was between a citizen of one state where the suit was brought in a citizen of a different state. Again, if you're not a principal or agent, then you're an alien. And they're dragging you into those courts as if though you're a party. You're not. You're not. You are not. You're the benefactor in all cases. I wouldn't claim anything else. Benefactor is the greatest position to hold because as a benefactor, you take the benefit of the word, which is the true benefit. Knowing the wisdom of his word. You don't have to accept their definitions. Again, many times I've done several videos on definition alone. A definition is merely another man's opinion. Nothing else. As Alexander Hamilton explained in Federalist number 80, there is hardly a subject of litigation between individuals which may not involve those ingredients of fraud, accident, trust, or hardship, which would render the matter an object of equitable rather than of legal jurisdiction. I'm going to read this again. Alexander Hamilton explained in Federalist number 80, there is hardly a subject of litigation between individuals which may not involve those ingredients of fraud, accident, trust, or hardship, which would render the matter an object of equitable rather than of legal jurisdiction. If that's the case, then why is nobody bringing equity? Why are these attorneys not addressing equity? Because they can't. They're trustees. They can only bring legal jurisdiction. The only way to bring equity is from outside of those jurisdictions. The English rules of equity, as modified by the Supreme Court, empowered federal courts sitting in equity, these would be judicial courts, to provide relief in exceptional cases. Wait a minute. Alexander Hamilton just said there is hardly a subject of litigation between individuals which may not involve those ingredients of fraud, accident, trust, or hardship, which would render the matter an object of equitable rather than of legal jurisdiction. Yet it says here the English rules of equity, as modified by the Supreme Court, empowered federal courts sitting in equity to provide relief in exceptional cases. So what is the exception? Again, you're not of the legal jurisdiction. I have an exception. I'm not a legal entity. This is in all cases. You can separate yourself from the legal entity. And therefore, it would render a hardship by forcing you to operate as a trustee. How can I operate as a trustee if I don't know the trustee duties? Do you have a record yourself that anybody in your trust has trained me how to operate in your trust? No. That's as simple as it gets, folks. If you don't know the duties of a trustee, they can't hold you capable or culpable or responsible or liable as a trustee. That's the hardship. Come out of her, people. Come out of her. For example, ordering that restitution be made to victims of fraud for whom common law provided no sufficient remedy. You committed some fraud against a local store, and that fraud was so grievous it caused the store to go under, and he could no longer operate business. Common law can't bring that remedy. Equity can, but it only does it through a legal fiction that says, okay, we've got a probated estate of this criminal. He's obviously incompetent. We're going to administrate it, and here's some funds from his estate, and here you go. We're going to fund you so you can start a new store. That's equity. And it's all based on a credit system, not a money system. The money is the paperwork. And they're going to take your credence if you prove to be a criminal through equity to provide a remedy in common law for the guy that you aggrieved. Enforcing specific obligations reflecting the intent of contracting parties despite the accident or mistake of one of the parties. So even though you are incompetent as a minor, they will contract your legal entity. Okay? They will contract your legal entity under their administration. They created it. They can contract it. This is the importance of those recognizing in those courts. They have the thing where you can change your name, and lo and behold, that's what I mentioned earlier. You just can't do it to avoid law. You can do it to change your effects in the future because you recognize that through using that legal name in the past, it's caused detriment. And in order to provide part of your equity, you change the name so that you can collapse that trust and merge it into a new trust. And now the new name is clearly recognized as a trust name. Now you can go strictly by your private name, which is your first name only. Okay? Issuing injunctions in cases where a party might otherwise be subjected to irreparable harm. Again, if you cause a fraud that might cause a commercial store to go under, they can place an injunction against all the transactions um, through the banking system and revert them back to that store owner. Had a case where somebody, through identity theft, well, actually stealing some checks, went around and overdrew my account by $1,700 or some shit. And as soon as I recognized the first check, I had an account stopple placed, and then found out that they placed all kinds of checks all around town. So it was an immediate stopple against all the others. And the bank tried to tell me that they couldn't stop those. They had to wait for them to come in. I said, no, you have to stop the account right now because it's causing a detriment to me. I'm the benefactor. And they understood that. And what they did was they created a new account for me. There are ways to do it. You just have to learn how things work and be creative in making your own remedies. Okay. So as we go, I want to be, and before I go on, I do want to remind everybody, I appreciate all your support. I appreciate you showing up. Please hit that like, share, and subscribe button. There are PayPal links in the details section for anybody who wants to share some love. Please do so. Everything is appreciated. Much gratitude. And the StreamYard link is pinned for anybody that does want to come up and join the panel. So, adjudicating disputes relating to trusts not within the scope of the common law. So if it's an administrative trust, which is known as a legal fiction, is that common law? Common law, folks, is an extension of the scriptural background of the nation. And here for America, not the United States, that's not the nation, it's America's, and it's both North America, South America. It's the Americas, the American citizens use the scriptures of the 1611 King James Version of the Bible, not administrative code. The trust is established within the scripture and then recognized in common law, and then in their legal courts is converted through administrative code. That trust is false. Okay? That trust is false. A legal trust is a false trust because, like I said here, there is hardly a subject of litigation between individuals which may not involve those ingredients of fraud, accident, trust, or hardship, which would render the matter an object of equitable rather than legal jurisdiction. Not one jot, not one tittle shall you add unto or take away from the word of God. For every word of God is pure. It is a shield unto him who put their trust in God. I believe that's what Alexander Hamilton was talking about there. Because these contracts and these trusts legislated in these legal fictions are false. They have false terms in them, not from the scripture. How can it be a valid trust? If your trust is in God, how could you placate that as a valid trust? That's facetious. It's blasphemous. State law became of greater importance to federal equity in 1839, 50 years later, from the Judiciary Act, when the Supreme Court held that federal courts sitting in equity were bound to apply state laws that created or limited or eliminated a substantive right. I find this false. I find this impossible to believe that these people would do this, knowing that if equity is what it is, it comes from the scripture. Then how can you placate that the state law creates any kind of right? How can you placate that the state laws can eliminate any kind of right, when in fact they are subject themselves to the Ninth Amendment, stating clearly that the people have rights which are not enumerated. Whether or not such a right existed in Chancery, federal courts were not bound by state law, however, with respect to questions of procedures and remedies. Why? Because again, in this trust law, the benefactor is the one that has to step up procedurally with his remedy. Ain't no other way it's going to happen. And they're telling you this. A federal court could, therefore, grant the remedy in question, or excuse me, grant a traditional equitable remedy, even if the state had abolished it. And this is in cases of minors. A federal court could therefore grant a traditional equitable remedy, even if the state had abolished it. And conversely, could deny a particular remedy the state had created, unless the remedy in question was inseparable from a substantive right. Inseparable from a substantive right. That substantive right is your freedom of association, freedom of expression, and like I said, the equitable equality is other people's right to know. Pure and simple. Traditionally, equity suits also included those involving mistakes in contracts, dower rights, which would be the marriage license, and construction of wills, as well as large number of petitions for freedom from slavery and government. Traditionally, equity suits also included those involving mistakes in contracts. Remember, we spoke yesterday, traditional versus custom. Traditional equity suits also included those involving mistakes in contracts, dowers, rights, and constructions of wills, as well as a large number of petitions for freedom from slavery and government. So let's go back in time to the tradition of equity and start acting in equity. Finding the mistakes in contracts so we can dismiss them. Finding the mistakes in the wedding license so we can dismiss them. Finding the mistakes in these false wills and dismiss them, as well as the petitions from the government of known as legislation to enslave and govern the people. Okay. Got a couple of links here. U.S. Constitution Annotated Amendment 7, Civil Trials, Trial by Jury in Civil Cases. We're not going to look at this because when you enter equity, like I said, you're not going to enter into the court. You're not going to have a trial. So when the Seventh Amendment says trial by jury for suits of $20 or more, they're talking about a common law trial where the law can provide a remedy. Okay. The only way that common law can provide a remedy in that situation is if you are in fact a resident or United States citizen, principal agent acting in those capacities, and you know it. From legal or LII-WEX, equity, in law, the term equity refers to a particular set of remedies, the traditional remedies provided in equity we just spoke of, and associated procedures involved with civil law, the common law procedures. These equitable doctrines and procedures are distinguished from legal ones. So if they're distinguished from legal ones, and the only case under civil rules of federal procedure, rule number 2 says there is one form of action, that action is civil, then you have to bring a civil action in equity. While legal remedies typically involve monetary damages, equitable relief typically refers to injunctions and specific performance, or vacatur. Vacatur is telling you you're not part of that. You are vacating that position. You are retiring. You are resigning from what you have signed. You are rescinding your signature. Had you known it implied that you were performing specifically, then you wouldn't have done it because you didn't know the specifics of the performance. You found mistakes in that contract of performance. See where we're going? However, if monetary damages are equitable, they will be involved. Doesn't typically involve the money damages, but in equity, in correcting the record, if you put something in, then it should come back. Those were the monetary damages. Okay. A court will usually award equitable remedies when a legal remedy is insufficient or inadequate. And again, their legal remedy placates that you have to partake of the legal name. I'm not qualified to partake of that legal name. I'm qualified only as a benefactor. Ask my Father which art in heaven. He's my Redeemer. I fear not. He's the one that called me by thy name. I am his. Aren't you his also? For example, courts will generally award equitable relief for a claim which involves a particular or unique piece of real estate, or if the plaintiff requests specific performance. So say, like I said, that store owner, you committed fraud against the store owner, and the claim was brought in equity. And rather than having you pay it back because you were vacatory, they found out you're not competent. What they can do is have you go work for that store manager for, say, 6 months to cover the expense of your fraud. It's indentured servitude, and that is lawful. That can be an equitable remedy. Exchange of labor for something you've taken wrongly. Origin. The distinction arose in England, where there were separate courts of law and courts of equity. Following this pattern in America, some states created chancery courts, which deal only with equitable relief. In other states, the courts of common law were empowered to exercise equity jurisdiction. Today, separate courts of chancery have largely been abolished. Largely doesn't say totally or has been. It says have largely been abolished. At the same time, or as the same court that may fashion a legal remedy has power to prescribe an equitable run. Okay. I ran across an interesting form called AO 430. And what it is, it's a nice little document from the Administrative Office of the United States Courts, case information record. Or for people with single cases that they want to do, we can put the single case number right here. This top corner right here. And of course, the district would be the District Court of the Black Hawk County. Location would be the street number and name. Type of proceeding. Equity. Plaintiff. Notice it says here in this square here, it says plaintiff. And it's got 4 boxes that you can check, one or the other. It says other, government, debtor, plaintiff. and those are of like kinds. So that means the debtor is specifically, or the plaintiff is specifically a debtor, and the plaintiff is the government. Everyone coming forth in these claims in these courts are acting as a principal or agent of the government. And they're making a claim against a creditor who is not part of the government. Notice there's no government over here. That means you're either a private or something external, alien. And notice it says defendant, other creditor. They know the defendant is creditor. They know the plaintiff is a debtor. And this is not a jury trial. You're coming in equity, as you said. And the presiding judge names goes here. And he's not a district judge. He's not a bankruptcy judge. He's not a magistrate judge. He is other. He is the chancellor. And that confirms or is affirmed in trust law that the debtor, or excuse me, the benefactor can come forth and assign a trustee. This is an assignment. This is a form where you get to make an assignment. I'm not telling you to do this. Don't take this as legal or lawful advice. I'm showing you a form and a possible way to use it. You would have to get more advice from other people that have used it and maybe do some research so you can maybe ask them of the same kinds of things I'm asking. Like here, it says plaintiff, other, government, and debtor. That is literally telling us the plaintiff must be a debtor, while on the other side of the ledger, this line going up and down, the other side of this ledger, it's a ledger, okay? Notice it's a T ledger. It's got a big box across the top, and then all of a sudden a line going across here, and then it goes down. That's a big T. That's a T ledger. It's a T ledger of information on this side and this side. One's a debtor, one's a creditor. They have a debit side and they got a credit side. Okay? It's a financial instrument. Learn how to read. I want to thank everybody for joining me today. I appreciate everybody's support. I urge everybody to unlearn what you've learned. Go back and relearn, specifically concise English. Get yourself a concise English handbook. Learn how this stuff is organized on these documents. Learn how to write this stuff down. A college composition handbook I also recommend. I also recommend the 1611 version of the King James Bible because that's what they placate under Public Law 97-280. That is the foundation of their very common law known as the supreme law of the land. It might take a bit of study, but I guarantee you, when you went to school, they didn't teach you how to study. They taught you how to look at something and remember it. Learn how to do your research. This is called studying. And research means multiple sources. Don't stop at the first Google thing and say, okay, now I know. Read several of them. Go on to another page if you have to. Find out enough sources that you can use to determine for yourself that you have a good, reasonable, and logical comprehension of what it is, so that you can formulate a question that you can ask somebody else to get affirmation of what your discernment is. No other way can it be done. You've been taught to remember everything that's bullshit and not to really study what is true. So in the meantime, I want to remind everybody on your way out, please make sure you hit that like, share, and subscribe button. It's important to help the algorithms to get this information out. If you really want to help your future generations, share it with them. Start teaching them. Become that teacher. Again, the basic benefit is knowledge. My people are destroyed for lack of knowledge. And the important lesson in teaching a man to fish is not only that he feeds himself for a lifetime, but that he's able to pass that lesson on to others. Not just to fish, but to teach. Teach. Did you know? Sermon on the Mount. Doctor literally means preaching from a hill. Preaching from higher ground, teaching a higher knowledge, a greater truth. It's literally what doctor means. Do you think these doctors are teaching you a thing? I find it pretty facetious that a doctor would think he knows all this Latin and can't understand the English language. Suppose that's why they take a dual oath. They pledge, they live in this Christian society of Abrahamic religions, yet they pledge an oath to Apollo and the Greek gods. Oops. Did they not know how to read? Did they not study Greek mythology as an obverse or separate and totally different than Christian? It's just so profound. And I don't see why people don't see this stuff. Please wake up, open your eyes, learn how to read, learn how to compose, learn how to pose what you are. So as I said, many thanks. I appreciate everybody's support. Like, share, and subscribe. PayPal links. We're done with the StreamYard, so don't hit that. Don't come up on panel. I'll see you next time. In the meantime, remember, I do love you, but I don't give a rat's ass whether you love me back. Please, may God bless you. Have a good day. We'll see you again next time. Bye now.